Well, how I think it maybe bleeds into my question about how how I've had an appointment that's been useful, and Judge Chen previewed that. I think probably the most beneficial example I have is where I asked the litigant if they wanted the assistance of counsel, wanted to see if they wanted to have counsel appointed, and they were very interested. And this was very early in the case because there were some interesting discovery challenges. There were issues of privilege and issues of jurisdiction and things that are hard for lawyers to unravel, let alone a pro se litigant. And our pro se help desk, through your good efforts, how found a good fit, and it was a junior attorney with supervision, and it was sort of, okay, help with this discovery, and then help with the settlement conference, because that can be an important juncture in a case. I think that's really an opportunity for a litigant and the lawyers to step back and see the landscape of the case, and to help interpret that landscape for a pro se litigant, without telling them what to do, of course, but advising. And then, like in Judge Chen's example, the attorney and the supervising partner thought, gee, this is such a good, it's such a good learning tool. And if the pro se litigant we would like to stay on. And so they did. All the way through pretrial. The case then resolved before trial. But I think of that case often because sometimes our pro se litigants, and we may have some here in the audience today, don't want appointment of counsel, and that's fine. I always like to make sure they know about our pro se help desk and the opportunity. And if they don't, that's their choice. When we get to sort of time for settlement conference, I always revisit the issue at that point, because I think it is so helpful to all the parties to have an attorney, even just for that limited representation. And in some of my cases, they've accepted and used counsel for settlement. Maybe the case settles, maybe not. And if not, then the client doesn't want further representation anyway. They want to do it on their own, and that's fine. But I do try to always revisit and just let the litigant know that our vast bench of volunteers are available, and they are experienced in whatever the case is. And in the case I was talking about a moment ago, that was an employment discrimination case, and I think that has probably been the most common case for me where I've had pro bono appointments. And I'm just always so pleased that it does provide good opportunities for counsel. It's just a real hands-on learning experience. And I think the supervising partners appreciate it too. And I know I had that role when I was in private practice. And, you appreciate the opportunity for younger lawyers to develop skills, but develop with supervision. It's not like a pro se litigant is getting just an inexperienced lawyer who doesn't know how to manage their issues. There's always a good hand and an experienced eye there. And it seems very beneficial all the way around. The litigant, for counsel, and of course for the court.